Hello and welcome to this edition of Company Law. In this lecture, we will be going through a very typical but a short topic, which is section 67, which speaks about restriction on purchasing by a company of its own shares, or giving of loans for purchase of its own shares. So this particular section, that is section 67, is a restrictive section provision which puts a restriction on companies to purchase its own shares or giving of loans to any other person for the purpose of purchase of its own shares. Okay, let's get into section 67 without wasting any time. First point is that no company having share capital shall have the power. So no company will have the power to buy its own shares. This is not applicable to section 68. Section 68 speaks about buyback of shares, but it has a separate and different conditions and procedure. Okay, section 67 says a company having share capital shall not have a power to buy its own shares unless consequent reduction of share capital is effected. That means section 66, which we had done in our last lecture, will be applicable in case a company goes for buying its own shares under section 67, and it will result into reduction of share capital. So no company shall have power to buy its own shares. This point is clear. This is the first point. Okay. The second point is that no public company. Which company? Public company. No public company shall give directly or indirectly, whether by means of loan, guarantee, security, or any financial assistance for the purpose of purchase or subscription made or to be made by any person or for any shares in the company or in its holding company. That means the second point says the company shall not give loan, guarantee, security, or any financial assistance to any person for the purpose of purchase or subscription of the shares of the company, of the own company, or its holding company also. Say there is, for example, company A shall not buy shares of company A. This is point number 1. So the company A shall not have powers to buy shares of company A itself. Its own shares it cannot buy unless it is consequent due to an effect of reduction of share capital. Okay, this is your point number 1. Point number 2 says that company A shall not give any loan or guarantee or security or any financial assistance to any person to either purchase shares of A company limited or purchase shares of, say, company Z, which is the holding company of A company limited. So this person cannot get any loan, guarantee, security, or financial assistance from the company for purchase of the shares of that particular company, that is company A in this particular example, or its holding company, which is company Z. So both these transactions are restricted under section 67. So I hope with this example you would have understood both point number 1 and point number 2. Okay, but there are certain exceptions to these rules. Which we will learn in the following points. If the company which is providing loan or guarantee or security is in the business of lending of money, which is a banking company, if it is a banking company and lending is its ordinary course of business, in that case, it can lend money for subscription of shares or purchase of shares. Or if the loan guarantee or security or financial assistance is in accordance with the scheme which is approved by a special resolution for purchase or subscription of fully paid up shares in the company or holding company or shares held by the trustee. There are some shares which are held by trustees also, which are basically transferred to trustees for the benefit of the employees in a scheme of ESOPs. Or such shares are held by the employees, then in that case also the company may provide loan, assistance or guarantee or security. So the first one was lending being the ordinary course of business. The second one being under a scheme which is approved by a special resolution for purchase or subscription of fully paid up shares of the company or holding company or held by its trustee for the benefit of employees, or such shares which are held by the employees. Okay, the second point is also clear. Third exception is giving of loans by the company to persons in employment. Loans by the company to persons in employment other than whom? Other than director, other than KMP. For an amount. There is a limit for that. The limit has been prescribed. For an amount not exceeding their salaries or wages for a period of 6 months. For a period of how much? 6 months. That means, say for example, company A gives loan to Mr. Z, who is an employee of the company. Mr. Z is earning, say, 6 lakh rupees. 6 lakh rupees per annum is his package. Then the company A can provide a maximum of how much? 6 months of his salary or wages as loan for what? Loan for purchasing the shares or subscription of such shares. Then the maximum in this case will be 3 lakh rupees. Maximum will be how much? 3 lakh rupees. I hope this example is clear. But such Mr. Z shall not be director or KMP of the company. This is very, very important from case study point of view. So this point is also clear. Now, if a company contravenes the provision, that means company does not follow the provisions or comply the provision of section 67. In that case, there will be fine of 1 lakh to 25 lakh rupees. 1 lakh to 25 lakh rupees to the company, and the officer in default can face imprisonment of up to, which may extend to 3 years, and fine of not less than 1 lakh and may extend to 25 lakhs, which is the same as the company. Okay, so that's it for me for section 67. If you have any doubts, please do comment in the comment section of this particular video and share this video with your friends. And if you have understood this lecture, do press the like button. It gives me a lot of motivation to bring up more videos in the future. And if you have not yet subscribed, do subscribe to the channel. That's it from me. Thanks a lot. Stay safe, stay healthy.